Yes, yes.
Very good. Hello and good morning from Singapore, Professor Dr. Dilip UK, Dr. Richard Albert, Professor Dr. Hannah Lana, Mr. Justice Mohan, and Dr. Singer, distinguished guests, ladies and gentlemen. Welcome to the inaugural session of the South Asian Research Colloquium on Constitutional Law. My name is Dian Shah. I'm from the Faculty of Law, National University of Singapore, and I'm here representing the Center for Asian Legal Studies, or CALS. Now, here at CALS, we're of course extremely honored and delighted to support and collaborate with Maharashtra National Law University Mumbai, the Indian Law Institute, and the University of Colombo for this colloquium. CALS was established in 2012 as part of NUS Law's strategic positioning as Asia's global law school. It is the first of its kind to be established in Asia, and we celebrate our 10th year anniversary this year. Now, since its inception, CALS has sought to become the leading institution for Asian legal studies. We started out with a solid grounding in research, mainly in the Southeast Asian region. And over the past decade, we have strengthened our engagement with other regions, including South Asia. Now, for me, South Asia, especially Sri Lanka, is close to my heart, as I started out my career doing comparative research between Southeast Asia and South Asia. Today, CALS plays a pivotal role in developing legal scholarship within the region, offering emerging and seasoned and established scholars the opportunity to spend time at NUS Law to research, teach, and participate in a variety of academic endeavors. Here at CALS, we have 4 research clusters in commercial law, civil law traditions, public law, and law and religion in Asia. And really, these 4 clusters speak to the intellectual diversity that we are trying to cultivate here at the center. And our work has been interdisciplinary, often engaging with other disciplines such as political science and history. So again, we are extremely delighted to be working with all of you in this initiative, and are looking forward to more collaborations in the future. I want to also take this opportunity to wish everyone a good and meaningful inaugural session and a successful colloquium in the weeks ahead. Thank you.
Thank you, Dr. Dan. Now I take great pleasure in inviting the person who has been instrumental in developing this idea into a reality. Professor Dr. Dilip Bouquet, sir, our Vice Chancellor of National University Mumbai. Over to you, sir.
Thank you, Mr. Aditya. Mr. Justice Mohan, Permanent Representative of the Sri Lanka to United Nations in New York, Professor Anna Lerner, Professor Richard Albert, Dr. Diana Shah, Dr. Kokila, Professor Manoj Kumar Sinha, my colleague, Professor Anil Variyat, the coordinator of the program, and who is the brain behind this, Mr. Aditya Variyat, and dear participants. A very good morning, good evening, good night to all of you. The idea behind organizing South Asian Research Colloquium on Constitutional Law was rather floated by Mr. Aditya originally. And we thought of how to do, because the basic object was to provide a platform to scholars, research scholars in a South Asian region. Maharashtra National Law University Mumbai, which was established in the year 2015 when it started its academic journey, we offer integrated 5 years BA LLB honors as well as 1 year postgraduate degree of LLM. Along with that, few master's courses like MA Mediation and Conflict Resolution. we started launched from last year, as well as LLM in investment and security laws, the unique program in association with the SEBI's NISM, we also started. We are now 15, 16 centers. Recently, we have added the Center of Research in Air and Space Law, being headed by Mr. Aditya, and he's also looking after the research division of the Maharashtra National Law University. As I said, that the idea when it was conceptualized, we wanted to take it forward, and that's why then we thought that it is better, since it is the South Asian South Asian region uh, research colloquium on constitutional law. It is better to collaborate with the South Asian countries, and that's the reason we approached the National University of Singapore, as well as the Colombo University, Sri Lanka, and our counterpart, the Indian Law Institute, New Delhi. I at the outset thank all our partners for extending their great support and helping hand for organizing the South Asian Research Colloquium on Constitutional Law. Dear friends, as we know, when the idea was floated and conceptualized, when it was taken forward, we floated the idea, we advertised, wherein we had received 200 plus applications, and out of which we had to select only originally 20. Then we reached to 30, and I think now it's 32 or 35 somewhat. The research scholars across the South Asian region, including even Australia, Sydney, as far as I remember, they are there. But yes, they are from the South Asian region. Wherein even the resource persons we have drawn and invited, requested them to join so that they can guide, they can contribute in the research in the area of constitutional law. As we know that the democracies around the world, and particularly in South Asian region, there are certain challenges, there are certain issues being encountered, surfaced by all the democracies, particularly in South Asian region, as India, Sri Lanka, Pakistan, Bangladesh, so on and so forth, Nepal, even in a recent times. So that was the reason, basically, that the issues either about the democracy or the constitutionalism or rule of law, so on and so forth, how to deliberate upon these issues, and then if possibly to enlighten the all the people in the region, so that we can strengthen, if try to strengthen, not, of course it is not in our hand as such, but the academic deliberations and that research does contribute in a great way, and that's why the guidance was sought, like Mr. Justice Mohan Paris and all other academicians across the world, across the globe. I'm confident that the first workshop, which has been scheduled in this month on 22nd and 23rd, and accordingly, then the second workshop will be scheduled in the month of maybe March or April, and third one, which will be ultimately culminated in the international conference. And we hope that by the time the pandemic will be over and we can meet physically possible, and finally it will come out in the form of book. So it is a great platform to the research scholars who have been selected from South Asian region, and we are confident that the resource persons will contribute in their knowledge, as well as will greatly be beneficial to all of us. With this, I conclude. Thank you so much.
Thank you, sir, for indeed an enlightening address. So the theme for this year's colloquium is South Asian Constitutionalism, Crisis and Unstable Democracies. So we have two scholars with us who have been very instrumental in the development of this subject, and their works are indeed shaping the discourse of comparative constitutional law. First, I invite Professor Richard Albert, who is a William Stamps Farish Professor in Law and Director of Constitutional Studies at University of Texas at Austin, United States. He holds different positions across the world. His work is much celebrated. It's an honor to have you amongst us, sir. Over to you, sir.
Well, thank you very much. Greetings to everyone from here in Austin, Texas. Good day to the Vice Chancellor, to Mr. Justice Mohan Paris, to Dr. Variath, Dr. Kumar Sinha, Dr. Konesinghe, Dr. Shah, my colleague, Dr. Lerner, my colleague. It's such a pleasure to be with all of you. And I want to send a special hello to the guest of honors for today, to the participants enrolled in this colloquium. Thank you for having me today, to the organizers and to the hosts. It's a great pleasure to be with you. I want to note especially one of my own dear friends who's a program director in this colloquium, Dr. Jacqueline Nail, who is a member of our inaugural class of senior research fellows here at the University of Texas at Austin. Congratulations to the organizers once again for selecting a timely and important theme for your colloquium on South Asian Constitutionalism, Crisis, and Unstable Democracies. I've been asked to speak briefly on two things. One is the importance of comparative study, and two is publishing. I understand that as you begin your work together today, you'll be gearing up for writing articles, perhaps books, and I'd like to give you some thoughts about publishing, specifically as to books. First, however, I'll say just a word or two about the importance of comparative study. Once again, though, thank you for your invitation. I'm really grateful to have the chance to be part of launching this important program. The rise of comparative constitutional studies has made our world much smaller and more accessible than ever before. Today, comparatists in one part of the globe weave into their scholarship frequent references to constitutions from another. Scholars can, of course, travel abroad for research stays to immerse themselves in a new constitutional experience. And constitution makers search beyond their borders for innovative and successful designs for use in their own local context. It's no exaggeration to say that we find ourselves today in an era of unprecedented interest in understanding and learning from others, as individuals and institutions invest enormous amounts of time and resources into facilitating cross-national exchange and education in constitutional law. And yet, some parts of the globe are still waiting to be discovered by scholars here in North America. In his recent book on comparative constitutionalism, Professor Ron Herschel, who's my colleague here at the University of Texas at Austin, he observed that, quote, the constitutional experiences of entire regions, from the Nordic countries to sub-Saharan Africa to Central and Southeast Asia, remain largely uncharted terrain, understudied and generally overlooked. Herschel was emphasizing Asia, South Asia in particular, because with few exceptions, South Asia has remained understudied and indeed underappreciated here in North America and other parts of the world as well. That's why I'm so thrilled to see Dr. Shah here partnering with all of you, because she is an integral player at NUS's Center for Asian Legal Studies. I want to congratulate them for their work in helping to shine a light on Asia and South Asia around the world. The region has been understudied and underappreciated, not only on its own terms, as part of the larger world whose constitutional systems merit attention from scholars seeking to understand constitutionalism in all of its varieties, but moreover, for how the lived experiences of the countries of the region can help illuminate new and productive approaches to challenges facing constitutional states around the globe. Your colloquium and the scholarship that will emerge from it in the weeks and months ahead will help fill the enormous void here in North America and in other parts of the world in our comparative knowledge of the constitutional systems of the world. I study South Asia, and I've come to appreciate very much how much we can learn from the constitutional experiences in the region. I know that jurisdictions in the region hold promise for deepening and enhancing our understanding of constitutionalism. Without knowledge of the traditions and experiences in the region, one cannot fully appreciate the vast possibilities for constitutionalism, both in theory and in practice, and more specifically in its design, its interpretation, its application, and its enforcement. I think just as importantly, engagement with the region will teach readers about their own jurisdictions as they spot similarities and note contrasts that bring into relief the values and specificities of their own systems. And so your colloquium that you opened today is part of a number of important efforts being undertaken to help bring South Asia more deeply into comparative constitutional analysis here in North America and in other parts of the world. They're critical efforts, they're exciting efforts because they will help to reveal the region both to seasoned and newer scholars and to interested readers from all corners of the world. And I think that efforts like yours will help push the field of comparative constitutionalism forward in exciting ways. So that closes the first few thoughts I wanted to share with you about the importance of comparative study, but specifically the importance of your efforts in building and implementing this colloquium. If I could now, I'd like to say a word or two in the time that I have left on publishing. And if I could, with your permission, I will share a screen. I don't know if I'm authorized to do that. If I am, I will try to do that, colleagues.
Yes, you can share it, sir.
Thank you. It says host has disabled participant screen sharing. Maybe I can try again.
So you can try again. I've just made you a co-host.
Thank you very much. And let me please know in a moment if you can see my screen, which should now be full screen. Do you see that?
Yes.
Great. Thank you very much. So I'd like to take the next, I have 12 minutes left. I'd like to take the next 12 minutes to walk through with you some of the considerations that you should pay attention to as you prepare book proposals. And I should say that I am a series editor for a number of book series in the study of constitutionalism, and I'd be particularly interested in receiving proposals from your group because we don't give enough coverage, not only in my series, but in many series, we don't give enough coverage to South Asia and constitutionalisms in the region. So I am a series co-editor for the Oxford series in comparative constitutionalism. This is a number of the books that we published recently. Note a book, the bottom left, on the Global South in comparative constitutional law, which was published a couple of years ago. And just last year, we published Constitutional Change in the Contemporary Socialist World, a book in which the author does engage quite closely with South Asia. This is very much of interest to us, and so we encourage you to think about our series. I'm also involved as a series editor for the Routledge series in comparative constitutional change. Now, I want to flag this series for you quite specifically because our most recent book is this one, The Law and Politics of Unconstitutional Constitutional Amendments in Asia. And there is a strong emphasis on South Asia. The third and final series for which I serve as an editor is on constitutionalism in Latin America and the Caribbean. Probably less relevant to this group, but still, I thought I would flag that to you in case it's of interest to you. Now, let me now turn to the mechanics of a book proposal because I am very much interested in receiving proposals from you on constitutional questions in the region. The basic details that one should put in a book proposal is, of course, a working title. Second, an anticipated delivery date. 3, an estimated word count. And then 4, a note on whether any parts of the book that you propose to submit will have been published in another forum or format before publication as a book in our series. Okay, so you propose a title, a delivery date. So you might say, here's my proposal, all things proceeding well, I should be able to complete the manuscript by January 1st, 2023, for example. An estimated word count, which should include footnotes, and then again, prior publication. These are basic details that you should put into a book proposal. But there's more, of course, and these are some of the more complicated, more important, I would say, details to put in a book proposal. First, what's the thesis that you're advancing in the book? And what is the significance of the thesis that you're advancing? So it's not sufficient to say, this is the thesis. You should explain why it's an important thesis, why readers should be interested in the thesis. And one way of getting to the significance of the thesis is by explaining the second point. What is the competing and related scholarship in the field around which you're basing your thesis? So you might, for example, think of this as a literature review. What else has been written on your subject? What have scholars said about the subject that you're proposing to write about? And more importantly, how is your approach? How is your thesis different? That speaks to the significance of the thesis. 3, your proposal should include a detailed table of contents, which dovetails very nicely with a chapter by chapter description. So imagine your manuscript will have 7 chapters, not including an introduction and a conclusion. Just imagine, it could be 5, it could be 4, it could be 6, but just imagine it's 7. Your proposal should include a description, a careful description of what you will say and argue in each of the chapters. And so, for example, you can put your chapter heading, chapter 1, and then have a description of what you will plan to do in that chapter, and also explain how that chapter will advance your thesis. Will it be a useful exposition of the background to your thesis? Will it be where you make your most important arguments? Will it be where you address counter arguments? These are the things that you should be doing in your chapter by chapter description, which works, I think, very well in tandem with a detailed table of contents. Okay. Now, a proposal should have these components in it, as well as the basic details that I've mentioned. Those amount to the proposal, the basic details and these critical components. That's the proposal. But you should also include a CV. And you should also include at least 2 chapters written as draft chapters of your book, okay? Of your proposed book. Because we take those chapters, we take that CV, we take that proposal as a package, and we send it to external reviewers for their evaluation. They will read your materials and they'll prepare a report with comments, criticisms, feedback for the author. And then once you get those criticisms, that feedback, that report, you are to write a response to those reviews, explaining whether you agree with the criticisms and the feedback, how, and if so, how you will integrate those comments into your manuscript. So how will you revise your manuscript in light of those suggestions? Now, number 4 here is reviewer conflicts of interest. This is not a necessary thing to add as part of the package when you're proposing a book, but it's something that you should consider adding if you wish, because it may be that there are scholars in your field that you don't want to review your proposal for a book, either because you are, for example, very close colleagues and co-authors, right? That would be disqualifying if they have worked directly with you on some of the materials and ideas that you're proposing in your book, right? Just as a matter of arm's length reviews, that's not the kind of person who should be reviewing your work, just as a matter of academic integrity. So you might want to discuss with your colleagues, your mentors, might want to discuss who that might be, if anyone at all, and then highlight that for us in your proposal. It may also be that there are people who are on the opposite side. So not co-authors, not collaborators, but people with whom there is a certain kind of antagonism over ideas, or maybe even personal antagonisms. Now, this is not always the case, of course. Hopefully it's rarely the case, but sometimes it's the case. And you're free to make that known to us as people who should not be asked to review your proposal for a manuscript. Let me just take a couple of more minutes because I see that I have about 2.5 minutes left. Perfect, that's just as I'd hoped. Let me take just a couple more minutes to highlight just a few more things about the proposal. When the time comes for the external review of your proposal, these are the kind of things that the reviewers are going to consider as they're evaluating your proposal for a book. They're going to assess your familiarity with the literature. That's why your literature review is so important. When you situate the significance of your thesis in the field, where you enumerate and highlight and describe the competing and related scholarship, they're going to be evaluating that. The nature of the contribution your book is going to make to the field, this is basically an evaluation of your thesis. Is your thesis going to add something of great significance, of interest, of usefulness to the field? Third, they're going to consider the coherence and the structure of the contents in your proposed book, which is why I suggest that you have a detailed table of contents, as well as a chapter-by-chapter description that explains why one chapter is coming directly before or after another, so that the readers know why you've designed your book the way you've designed it to be, so they can see the book through your eyes. The reviewers will also evaluate the strengths and weaknesses of the proposal, and they'll put those down in a report that they'll write for you. Now, they'll be anonymous to you, their identities will be concealed. They'll also think about ways to improve your book, and they'll give you suggestions. Have you thought of this? What about this? Have you read this book or that article? You might want to think about this or that. And then finally, as I see I have about 30 seconds left, finally, they will ask themselves whether your book that you propose to write is one that they would assign in a class that they teach and or read for their own interest. So these are the kind of things that peer reviewers, external reviewers, will consider when reviewing your proposal to publish a book. I'm going to stop sharing my screen now, and I'll take just 15 more seconds to say just 2 more things. One, I will say thank you once again for your invitation to be here. I'm excited for all of you. I'm looking at the room and I recognize some names, in fact, of early career scholars with whom I've interacted. So I'm very happy to see all of you here. 2, if any of you is writing about the subject of constitutional change, so constitutional amendment, constitutional reform, unconstitutional constitutional amendment, for example. These are the subjects that I'm interested in, that I write about. And I'd love to hear from you. I'd love to read your drafts. I'd love to be in touch. What I will do now in the 5 seconds I have left is that I will share with you something that I have written for those of you who are interested in the subject of constitutional change. And I invite you to have a look and then let us begin a conversation. Please don't hesitate to be in touch with me if I can be helpful To all of you, whether or not you're writing in my area of scholarly interest, it will be a great pleasure to have the chance to speak with you virtually online by Zoom or just exchange emails. Thank you once again to all of you for inviting me. It's a great pleasure to help launch your important event. I wish you great success in this program. Happy 2022. Thank you very much.
Thank you, Professor Richard. We thank you not only for accepting our invitation as a guest of honor, but we also thank you for the work that you are doing in this field. It is indeed changing the discourse of how we read Constitution and we approach Constitution as a subject. Now, I move on to our next guest, Professor Hannah Lennon. She is the head, School of Political Science, Government and International Affairs at Tel Aviv University, Israel. She's a scholar, and her research on the intersection of politics and law, and particularly the focus on comparative constitutional law, is indeed groundbreaking. So it's an honor to have you amongst us, ma'am. Over to you.
Thank you very much. Thank you very much for the invitation to participate in this exciting and important event. I'm honored to speak here today, and I congratulate you for initiating this important colloquium. It's especially a pleasure for me because I think that the colloquium is extremely important, not only from the perspective of South Asia, but also from the perspective of the rest of the world. The concept note on the colloquium claimed that, and I quote, "For a long time, the South Asian countries have looked toward the West for adopting the ideas and solutions to their problems, but these problems can only be solved by the indigenous and homegrown approaches." This is absolutely right. But I'd like to add that South Asian homegrown constitutional approaches are relevant not only for solving local domestic constitutional problems. South Asian constitutional experience has a great relevance for other parts of the world, including the West, which should look and learn from that experience, from the rich heritage of constitutional decision-making. And by decision-making, I refer to the broad area of choices made by political leaders, constitutional drafters, lawyers, judges, and institution builders. There's a lot of path dependency in South Asian constitutional and institutional development, but we also see great impact for agency, those political and judicial leaders who made important decisions that advance and protected democracy over the years. The past few years may have been marked by growing concern about the stability of democratic institutions in few countries in Asia and South Asia, in particular, as reflected again in the main theme around which this colloquium is centered. But I think that looking back into history, many of these countries have very important and useful constitutional legacy to lean on and to draw inspiration from. And I usually prefer to, I focus on the optimistic and kind of try to focus on the positive aspect. So studying these legacies is extremely important and may provide significant contribution to scholarship on constitutional law, political theory, and democratic theory, and the study of democratic institutions, again, around the world, and would also be helpful for practitioners interested in democracy building and democracy preservation. In particular, I think that Asian constitutional experience is relevant for the rest of the world with regard to two current shared challenges. First, the challenge of how to address pluralism and diversity and how to handle disagreement. And second challenge is related to the conditions of what I'll call social emergency caused by the current global COVID pandemic and other types of social emergencies, such as, for example, climate change, but I'll focus on COVID. So in the rest of my time, if I may, I'll say a few words about each of these challenges. First, concerning diversity and disagreement. I always tell my students when I teach about my classes on comparative constitution making that with all due respect to theories of multiculturalism that evolved in Western countries especially around the 90s in Canada or the United States following theories like Will Kimlicka and others, I think it was Nehru, Ambedkar, and other Indian founding fathers of the Indian Constitution, who created not only the theories on democracy in plural societies, for example, the principles of such as unity without uniformity, which Nehru wrote about in his book, The Discovery of India, and talked about in his speeches in the Constituent Assembly debates. These political leaders have also created the constitutional and institutional infrastructure for implementing these principles in practice. And this is not something to be taken lightly. Principles such as non-justiciability in constitution making traveled across South Asia and across South Asian constitution, and in many respects inspired even Israeli debates on constitution drafting, especially concerning controversies on religious identity, the religious identity of the state. Another important legacy, which I think should not be underestimated, is the open and free nature of constitutional debates that occurred in many South Asian countries in the post-World War II period, and which were documented and even published. Some of them are even online. Such open and free Constituent Assembly debates, some concerned highly controversial issues, and especially their publicly available protocols, may have a long-term educative and instructive influence on political discussions by the following generations. Such debates may and perhaps should be read in the same way that we look at dissenting opinions published by Supreme Courts. The debates give voice to the competing perspectives concerning the norms and values that should underpin the state. The record of Constituent Assembly debates under conditions of deep divisions delineate the contours of the dispute and the scope of possibilities and choices that drafters had faced. This scope may be different and broader than the way a particular constitutional principle had been interpreted or implemented in the post-drafting stage, and may inspire reform, hopefully a liberal reform. So even if not achieving the goals of enacting a liberal, egalitarian, right-protecting constitution in the immediate aftermath of the drafting project, constituent assemblies can have an important long-term influence on the norms and values that guide state policies. And I think that many South Asian Constituent Assembly debates provide exactly this kind of insight or vision, which should be studied by domestic, but also by international students and scholars of constitutional law and politics. I do believe that this kind of constitutional legacy of agreeing to disagree is important for restoring democratic institutions, even if they've weakened or eroded over the years. The second constitutional challenge which the world is currently facing, and on which South Asian experience has, and in general, Asian, I think, experience has a unique perspective, is the challenge to democracy raised by the current COVID pandemic. And I'd like to expand a bit about the particular nature of this challenge, which requires us, in my view, to develop a new theory of what I call social emergency. When the COVID pandemic broke out, it was fascinating and a bit alarming to see how public discussion around the world, and also many political and legal scholars, addressed the global health crisis within the conventional framework of national security emergency, often using the metaphors of war and attack. This framework had converged during the past 2 decades, especially since 9/11, the 9/11 attacks in the United States and a series of terror attacks in Western Europe, around a set of constitutional repertoire, which basically relies on unilateral executive action with limited oversight by courts and marginal role for legislatures. The consequence of this model has been increasing concentration of power in the executive branch, growth in the national security apparatus of the state, expansion of surveillance and intelligence gathering powers, increase in practice of secrecy, etc., etc. Moreover, this model has been correlated with some of the pathologies in democratic practice identified with democratic erosion, decay, and backsliding among consolidated Western democracies, including especially declining practices of deliberation and public trust in government. During the past 2 years, as the waves of COVID pandemic continue to spread around the world, many expressed the need to expand the understanding of national security emergencies and counterterrorism policies and technologies to address the war against the COVID-19 virus. To some extent, the common tendency to treat all emergencies as raising similar challenges, regardless of their source, is understandable. The familiar trade-off between safety and liberty, often perceived as a central feature for any emergency situation, is at play in health emergency as well. However, the last 2 years also exposed the limitations of the national security framework and the counterproductive nature of the conventional constitutional toolset it usually applies when addressing a global health crisis. I'd like to argue that this is because social emergencies, such as global pandemics, differ from our conventional thinking about emergencies in the national security context across 4 significant dimensions. So these are the 4 sort of distinctions between the 2 types of emergency. First, on the temporal dimension, by contrast to the acute crisis triggered by the discrete attack or series of attacks, a pandemic is a slowly growing, slowly evolving crisis of indefinite duration, so short-term versus long-term. A second difference concerns the dimension of knowledge and expertise. Modern states have developed extensive specialized knowledge in addressing a variety of security threats, and this knowledge is monopolized by governments. By contrast, the kind of multidimensional knowledge required for addressing pandemics is interdisciplinary and decentralized, that is often held by non-governmental organizations, either public or private. So, for example, hospitals, pharmaceutical companies, but also social workers, local municipalities, educators, etc. The third distinction concerns the question of transparency. While often decision-making under conditions of natural security conditions require secrecy, lack of transparency is counterproductive in cases of global pandemics on both national and international levels. International cooperation and cross-border sharing of information is crucial for controlling the coronavirus, for developing and allocating vaccine, and for finding other medical solutions. And on the domestic level, public health depends on open, transparent, and trust-based communication between the citizenry and their governments, which is a required condition for creating public compliance with policies such as, mask wearing and widespread vaccination. The fourth distinction concerns the different kind of values that stand at the center of public debate under the 2 types of emergency. In cases of national security emergencies, public focus is often on the trade-off between collective security imperatives and individual rights. By contrast, the nature and distributive of health vulnerabilities and economic risks involved in striking the right policy balance in a pandemic require choices on issues of resource allocation and social investment, which are based on a much more complex matrix of distributive justice values. Now, what are the constitutional implications of these distinctions? I'd like to suggest that the distinctive characteristics of social emergencies highlight the need to think of alternative constitutional repertoire for addressing transnational non-military crises, again, such as pandemics or even climate change, an alternative democratic constitutional repertoire. This alternative institutional toolset should shift the balance of power back from the executive to the legislature. This is because deliberative mechanisms and inclusive decision-making led by legislators seem to be much more appropriate tool for cultivating the public buy-in for policy recommendations and public trust in government needed in the midst of global pandemics. The COVID pandemic provided us with sort of a natural experiment for examining what kind of institutional and constitutional toolset is most appropriate for both handling health-related threats, but also for preserving democratic institutions, facilitating public trust, and prevent the weakening or erosion of democratic practices. And in many respects, Asian countries are crucial for further investigating and evaluating alternative constitutional frameworks in addressing both short-term and long-term challenges caused by the pandemic. Countries such as South Korea, Singapore, and Taiwan were ahead of the game due to previous experience with the breakout of SARS around a decade and a half earlier. I think there's much to learn from these and other Asian countries concerning the kind of participatory processes of decision-making for addressing pandemics, which perhaps should be based on both expert knowledge and inclusive public deliberation in representative institutions. To conclude, I'm speaking from a country located in Western Asia, bordering Africa and not too far from South and Eastern Europe. I mention these geographies because these parts of the world are used to look for the West for constitutional inspiration when addressing challenges concerning their democratic institutions. However, I think it's time for us to turn eastward because there are many important lessons to be learned from Asia and especially South Asian countries. So I very much look forward to the outcomes of this colloquium. And again, I congratulate the organizers and I thank you very much for inviting me to this event. Thank you very much.
Thank you, ma'am, for such a wonderful and insightful address. Next guest of honor is Justice Mohan. He is a permanent representative of Sri Lanka to the United Nations at New York. He had some ambassador level commitments, but he was very kind enough to send a recorded speech of his so that he can talk to you all. So I request someone to share the screen and play the video.
Good morning, ladies and gentlemen. May I first of all thank the Center for Asian Legal Studies of the Faculty of Law of the National Law University of Mumbai for inviting me to this colloquium on constitutionalism in South Asia, the crisis, and unstable democracies. Not an easy one. My dear friends, in today's world, the trend appears to be that nations were keen to pursue the ideal of a democratic system. So much so that even in authoritarian and socialist communist regimes, there is a strong and regular reference to democracy, although that may be in the context of their own understanding of democracy. On a close examination of the political structures around the world, of course with a view to finding out whether democracy really exists, one would be surprised to find that there are only a few real democracies. Academics have arrived at this conclusion by using the indicator of the holding of regular elections at the end of each term as constitutionally required. Now, when one applies this indicator, it is easily observed that it would be nearly impossible to attribute democratic status to many of the states. One would find that the leaders of these nations seek to justify their rule and their existence by propagating mandates and policy statements that are popular with the electorate, although the benefits of these mandates never ever flow down for the benefit of the electorate. What I am saying, in other words, is that the holding of elections and the renewal of popular mandates are not necessarily synonymous with democracy. It is only a stepping stone in the process of the establishment of a democratic government. Now, having said that, let me say a word about constitutionalism in its pure sense, simpliciter. Constitutionalism, my dear friends, is a complex of ideas, attitudes, and patterns of behavior, elaborating the principle that the authority of government derives from and is limited by a body of fundamental law. Now, the concept of constitutionalism is that of a polity governed by or under a constitution that ordains essentially what is known as limited government and the rule of law, as opposed or contrary to arbitrary, authoritarian or totalitarian rule. Constitutional government, therefore, should necessarily be democratic government. In other words, constitutionalism is a political philosophy in which functions of government of a state must be in accordance with the provisions of the Constitution, meaning thereby the actions of government must reflect constitutionality. As constitutionalism is a political spirit or philosophy, it is therefore not necessary that states who have a constitution must be embodied with the concept of constitutionalism. Now, according to Douglas Greenberg, constitutionalism is a commitment, he says, to limitations on ordinary political power. It revolves around a political process, one that overlaps with democracy in seeking to balance state power and individual and collective rights, that it draws on particular cultural and historical contexts from which it emanates, and it resides in public consciousness. Constitutional to the extent that they contain institutionalized mechanisms of power control for the protection of the interests and liberties of the citizenry, including those that may be in the minority. As described by political scientists and the constitutional scholar, particularly David Feldman, who says that constitutionalism is descriptive of a complicated concept deeply embedded in historical experience, which subjects the officials who exercise governmental power to the limitations of a higher law. Constitutionalism, he says, proclaims the desirability of the rule of law as opposed to rule by arbitrary judgment or mere fiat of a public official. Throughout, you will see the literature dealing with modern public law and the foundations of statecraft. The central element of the concept of constitutionalism is that in political society, government officials, and this is important, are bound to observe that government officials are not free to do anything they please in any manner they choose. They are bound to observe both the limitations on power and the procedures which are set out in the supreme constitutional law of the community. Now, that's important to appreciate. It may therefore be said that the touchstone of constitutionalism is the concept of limited government under a higher law. It is therefore not difficult to appreciate that constitutionalism is an evolving subject. You will appreciate that constitutionalism can only survive if its genesis is from within a framework of a society that recognizes the rule of law. It must necessarily have the features of substantive and procedural legal mechanisms and must ensure the concept of limited government. Although the field of constitutional law has become increasingly comparative in recent times, its geographical focus has remained limited. It is regrettable, I say, that South Asia, notwithstanding that it is home to the world's largest democracy and other vibrant democracies, is one of the most neglected regions in the context of constitutional law. The academic Herschel, who wrote on the renaissance of comparative constitutional law, he said says that many scholars and practitioners, including many well-known judges, no longer believe that the task of constitutional law and the appropriate methodology for comparative analysis is essentially domestic in nature. My dear friends, it is believed that the uneven nature of comparative constitutional law lends itself to only modest comparisons, that you cannot truly focus on the matter on a global basis with little attention being paid to South Asia. So let's look at it for a moment. India, perhaps, is the only country that appears in comparative discussions most of the time. The academics seem to suggest that the attention here is also less than one expects to see. And there's a good reason for that. The reason for that is that the focus is essentially on matters of peculiar interest to the West, such as the aspect of social rights, their recognition, and how they are decided upon. So, notwithstanding the fact that South Asia practices a vibrant constitutionalism, there have been perhaps very few attempts to bring together South Asia's many nations and engage with their constitutional difficulties. The chief reason for this might well be the reason that many issues are connected with the basic constitutional structure, which is intricately connected with political ideologies. My dear friends, let me very quickly present to you a bird's eye view of the subject in the context of India, Sri Lanka, Pakistan, Nepal, and Bangladesh, which are nations with varyingly different characteristics in the context of constitutional law. It must be admitted without demur that India has survived as the largest or the world's largest democracy with an active and independent Supreme Court, whilst Pakistan and Sri Lanka have provided reason for perhaps for equal excitement and curiosity of a different kind. Both Pakistan and Sri Lanka today are of geographical or geopolitical importance, and the academics seem to express the view, of course, as they regularly seem to do to keep the discourse alive, that both nations have a constitutional crisis. Now, I don't know whether that's academic overreach, but that is what it is. One has seen that in Pakistan there are tensions between the military and civilian rule, which decides the trajectory of the nation's progress. In Sri Lanka, the ethnic crisis is one of the past and appears to be now grappling with constitutional provisions with a view to ensuring true reconciliation. Nepal and Bangladesh are perhaps of lesser interest, although Nepal has been in the boiling pot of constitutional making and Bangladesh being under democratic rule for almost 20 years. One would perhaps accept, without devaluing the development of constitutional law in all these countries, that there is a continuous tension or undercurrent that lies beneath law and politics. It is said that these tectonic plates, these undercurrents, nourish constitutional development and the constitutional process. It is not difficult, therefore, my dear friends, to appreciate that what makes the South Asian scenario special is the high degree of tension between substantive formulations of the law and the social and political realities to which the law is required to conform to. It is presumed that the topic unstable constitution, whoever who chose it, was identified as an expression that describes the character of South Asian constitutionalism, which is a phenomenon in which all stakeholders in national politics are genuinely committed to the idea of constitutionalism in the hope of establishing permanent institutions with the capacity to deal with daily governance. Now, with all the will in the world, what we unfortunately see is something different. What we see, unfortunately, is that we in South Asia struggle to settle to a stable institutional structure based upon constitutionalism suitable for our own countries. When we look around us, what do we see? We see unitary national governments like in Sri Lanka, symmetrical or asymmetrical federalism like in India, confederations, multiculturalism, plurinationalism, and in all of this, the common thread is the dominance by the majority of the minority. Now, the commitment from a theoretical point of view that helps us to understand constitutionalism appears to have a turbulent relationship with, of course, the ground realities that are generated in the politics of these regions. So the term unstable constitutionalism appears to encapsulate the difficulties that are faced by the law between legal norms and socio-political facts, as well as the pressing challenges in defining the character of constitutionalism that would help to push a nation from civil rife to stability. My dear friends, the academics say that the central concerns of the countries that we just spoke of is not in the debates that interpret the constitutional text or the role of the constitutional courts. It is simply a question of constitutional design and negotiation that would ease the pressure on the systems of government and the risks that it will be exposed to as a result of the domestic factors. It is therefore easy to see that constitutional instability takes place. Look at it carefully. Where there is ethnic conflict, where there is social order and a high degree of diversity in which the stakeholders are supportive of the idea of a single state. It is therefore not possible for us, due to the constraints of time, to explore the theme of unstable constitutionalism, for it involves the studying of the different forms and sources of instability and the reactions and responses to that instability. Constitutional instability, you will see therefore, and you will appreciate, can present itself in numerous ways. Some countries might find it difficult to draft a constitution in the first place. After it is established, it is possible that some countries, the constitutional framework might be subject to several types of instability. An obvious example would be Nepal in the region. It appears that the failure of the Nepalese constitutional arrangement to give rise and due recognition to the representative arm of the government and to respond to calls for an inclusive democratic state have been the principal characteristics in recent history. Now, accepting that the free and fair elections are at the center of any democracy, then Bangladesh's experiment in conducting elections seemed to be a classic example. Since Bangladesh's move from military rule, few issues have dominated its constitutional discourse as much as the electoral process. My dear friends, I might mention in passing that Sri Lanka has managed the tensions between the majority Sinhalese and the minority Tamils and Muslims reasonably well. The failure to address the various issues have led to conflict from time to time. One conflict raged over 25 years, and in 2009 the civil war was brought to an end. Several political solutions have been attempted post-war, with Tamil political groups agreeing to a federal solution and abandoning their call for secession, although progress on this front could be much better. The federalism debate in Nepal and Sri Lanka has continuously been mooted. It is thought that federalism model can absorb conflict, but there is also a view that it can also make it worse, for the reason that ethnicity, whilst having the capacity to empower, can also divide and would give rise to federalism as a stepping stone to secession. You will therefore see that the vast and growing field of constitutional law and politics and its constitutionalism is something that can be subject to in-depth debate. To consider one example is perhaps the recent past has been the horizontal expansion of the jurisdiction of fundamental human rights to private actors and the related issues that this raises for the institutional allocation of responsibility to the superior courts. It is therefore necessary that we must study South Asia on its own terms to be able to understand it better. It requires that we develop our research agenda around the actual practice of constitutional actors in South Asia. Although one concedes that religion, state relations, and socio-economic rights have been important to constitutional practice, they have been not only the central topic of concern. An example that comes quick to my mind is the constitutional policy of official language status that has been the principal driver of shaping the political space in the late colonial and post-colonial periods. You will therefore see that to strategize the study of South Asian constitutionalism that has plagued constitutional stakeholders has opened the door, I say, to an alternative strategy of comparative case studies that opens a wide field beyond the narrow sets of jurisdictions that decide central concerns. I hope that these few ideas that I have thrown open before you would contribute to a successful conclusion of this colloquium, which is more than timely, and would thank the Center again for Asian Legal Studies at the Faculty of Law and its partners for organizing this colloquium, which has drawn focus on a topic of great importance. I thank you.
I'm sure that we'll hear more from this Mohan sir in our future workshops and in our final conference. Now it's time to hear some views from our program directors who have been instrumental in actually planning this whole program. I invite Professor Dr. Manoj Kumar Sinha sir, who is the director of Indian Law Institute and a renowned scholar in India, to deliver his address to the participants.
Thank you very much, Aditya. Honorable Vice Chancellor Professor Dilip Uke, Professor Richard Albert, Professor Hannah Lerner, and I think Ambassador Mohan Pasne and others here. Let me begin with congratulating Professor Dilip Uke sir for thinking about this idea that we should activate constitutional discussion and engagement, particularly in the South Asian region. And then he has given the shape also this entire idea. And today we are here to discuss. And then it's the first beginning of a great initiative taken by the Maharashtra National Law University, along with this National University of Singapore, Sri Lankan College, and the Indian Law Institute and other associated. In today's discussion, if I just three important points which have been highlighted, particularly by the Professor Richard Albert and Professor Hannah Lerner, and of course with the Professor Mohan Pasne. 2 points he highlighted, Professor Richard: importance of the comparative study and publishing books. Let me elaborate that in Indian scholarship, when we look into the Indian scenario, there are a large number of students are working on the constitutional topics, and their focus is, when it comes to the comparison, they go to the Canadian Constitution, USA Constitution, and also Australian Constitution. Like comparative, largely these are the, and sometimes they try to see in the United Kingdom and other jurisdictions, but these are the focus we have in India. And the Indian scholarship somewhere tend to miss South Asian perspective. South Asian has also extensively contributed in the development of the number of concepts which emerged in the late 20th century. For example, if I take in Bangladesh, Bangladesh is the first country after the independence in 1971 established International War Crimes Tribunal in 1973, much before the establishment of ad hoc tribunals in ICTY, ICTR, and International Criminal. In 1973, to try those who were responsible during the War of Independence in 1971 for the war crimes, crimes against humanity, and genocide. However, this has not came into reality, which came reality in the 2009 onwards. They have amended it, and then trial has taken. But most of the trials were taken before the Supreme Court of the Bangladesh. The landmark judgments on the international crimes, particularly they delivered by the Supreme Court of the Bangladesh, that is we need to look into that. So I see that particular development. The second important, which we miss also, when we talk about the transitional justice in the constitutional perspective, in the transitional justice, we have to go back to the Nepal. Almost 1996 to 2006, it was in a way controlled by the Maoists. And in 2006, the constitution has come and a lot of development has taken place. So even the concept of transitional justice, we can see, and how subsequently after 2006, Nepal has its ups and downs. It's still functioning as a constitutional democracy, and somehow constitutional principles are respected and courts are independent in Nepal. We have around 8 countries in the South Asian countries. If you put together 8 countries in the South Asian country, and we have to see how in the Afghanistan in days to come, how it unfolds. That is also very important aspect. Indian scholarship is divided in the domestic scholars and the international scholars. Many scholars, young scholars passed out from the national law schools. They moved out and they are settled in the Australia, Canada, Australia, USA, and even the UK. And they are writing on the Indian scholarship, on the constitution. There are a lot of good articles written by the Indian scholars working in the United States and other places. However, when we come back to the Indian scenario, we have scholars in the national law schools, also in these scholars in the some of the central universities and state universities who are contributing. But there is a time has come that we all have to bring the Indian scholars and even the foreign scholars working on the Indian Constitution wherever they are, and linking them with the one platform, which can be this platform which has been created by the Maharashtra National Law University. So constitutional scholars should be brought in a particular one platform, which I see today also. We have students from the number of places, we have scholars from the number of the countries who have joined together. Though number is not huge, but there are large number of students and scholars from the different jurisdictions are participating. This will always enrich the discussion related with the comparative constitutional law, which already there, but I need we need to, as Hannah, I believe she highlighted, there are a number of jurisdictions which has not been touched, like constitution and African continent, even in the Asian continents. Hardly we have understanding how the system function, what are the constitutional principles are there, what are the constitutional objectives there in these jurisdictions, which needs to be studied more in the Asian African. This is the journey which started with the Southeast Asian perspective. Now it's a South Asia. Maybe in days to come we can expand and we can go to the other jurisdiction. Let me if I come to the Hannah's point, Hannah has mentioned in her discussion about the emergency provisions. We have in the Indian Constitution emergency provisions, particularly Part 18 of the Indian Constitution, Article 350 to 360. And how this emergency provisions in this particular, whether it has been applied in the pandemic crisis, or we have how it crisis has been addressed, that is the important point to understand. In the if you look into the Indian Constitution, is starting from the Article 352 to 360, it outlines three types of emergency. The first is the national emergency, which talks about the in situation of war, conflict, and armed revolution, there is possibility of imposing national emergency. And in national emergency, most of the fundamental rights which are mentioned in the Part 3 of the Constitution can be suspended, except two rights which cannot be suspended in any emergency, that is the Article 20 and Article 21 of the Constitution. Article 20 is basically procedural guarantees, and Article 21 is very fundamental, that is right to life. Both are procedure 20, 21, right to life. But these two rights were not from beginning. It after the 44th Constitutional Amendment. After the 44th Constitutional Amendment, two articles have been acquired the status of non-derogable. You can say that's non-derogable or inalienable human rights, core human rights. It has become in the Indian Constitution. These remain in whatever situation, these rights will be always available to the citizens, non-citizens also, like nationals as well as the non-nationals. So in that context is there. Coming to the national emergency, which is the more war situation, it has been imposed three times. One on the ground of the internal, two times on the time of the Indo-China war, Indo-Pakistan war, and one internal emergency. Second emergency is since we have a federal system, we have a constitutional breakdown in a particular state. So it's state government can be suspended, which has been also used frequently for more than 100 times, but things have changed after 94, 95 onwards. But prior to 1994, there are a lot of occasions where the state government were suspended on the ground of the constitutional breakdown. The third ground is the financial emergency under the Article 360 of the Constitution, which has not been invoked. Now coming to the emergency, this particular time in the lockdown has been imposed, then curfew has been imposed. So IPC, CRPC, and the other relevant provisions have been used, and then also National Disaster Management Act and Local Disaster Management Act, which has a provision which has been used in this pandemic. Most interesting development which has taken place, and so Supreme Court of India had an opportunity in one of the case which was decided last year. It's a very interesting case. When you get a chance to look into, you can look into this. And I have a limited time, I'll not go in detail, but I say Gujarat Mazdoor Sabha and versus the state of Gujarat. Gujarat Mazdoor Sabha and versus the state of Gujarat. This case was decided by the Supreme Court of India, where what happened, the industries have used a particular Section 5 of the Factories Act, Section 5 of the Factories Act, which gives power to industry to curtail the wages, timing, and lot of restriction can be imposed on ground of emergency. But this Factories Act is intended to link with the national emergency, not on the pandemic emergency. However, Supreme Court has made it clear, and I'll just read out that like couple of lines what court has said. The Supreme Court has said in this particular case that existence of public emergency must exist. The emergency must be a grave emergency which threatens the country or any part of it. So it's like no emergency when he said, this pandemic cannot be any part of it. Upon fulfillment of this condition, proportionality test determining the validity of state action infringing fundamental rights must be fulfilled. So court has segregated basically that. Then another important that is I think unique, which world should know. In the role of the high courts and Supreme Court, particularly dealing with the pandemic, and particularly in the second pandemic, not in the first, second pandemic, which happened in the month of April 2021. Even the first pandemic, court has taken suo motu. Court has taken suo motu and asked the government regarding the management, how things are distribution of vaccine, medicine, hospital facilities. All these questions were raised by the court. And in fact, the last one, which in the April 2021 distribution, so the case which Supreme Court has taken suo motu, and title is the distribution of essential supplies and services during pandemic. That is the second case which has been taken by the Supreme Court of the India. And also many high courts also played very important role. So courts are equally, along with the executive, court also played very important role in addressing in the pandemic, in the and court used the constitutional provisions in the one of the case, in the second case, which distribution of essential supplies and services during pandemic. Government argued that is a policy matter. It's a policy matter how we are going to distribute vaccine and other things. It's not the court has to decide. It has to be decided by the government. So policy matters should not be taken by the court. That is the Lakshman Rekha or a division is there. But court said, if policy matters infringes fundamental rights of the constitution, or then court will not hesitate to jump and take into that particular part. So court has clearly made. So we are respecting the doctrine of separation of power. But if any organs fail to perform its duty, court will not hesitate to undertake that, to enter in that particular arena, which actually belongs to the other organs of the state. And that is the reason in the vaccination. And the vaccination policy, if at all, has changed and become very useful. What we see in the television, in the developed nations, and we compare with India, I feel personally very proud the way we have the facilities, despite having a huge population. There's no problem in getting vaccination. There's no problem in getting of the test. And even if you have a money, then everything is very easy, not very expensive. So India is very ably tackle the pandemic, and services are not in the admission in the hospital, but vaccination, testing, and other parts are very easily available to everyone. And that is a commendable in there. Just to conclude, what I we say that for Professor Richard, which I have mentioned him also in the chat, that we have in the Indian Law Institute that we focus on the constitutional law and criminal law. We have 4 or 5 students who have done. Professor Richard, if you are there, they have submitted their thesis, they have been awarded, and they all worked on the constitution, Article 19, 20, and more or less there's a comparative on that. And the students' name are Baisali, Sakshi, Daksha, Meera, and Neha. They all have submitted on the constitution. Maybe I'll encourage not only on my university, also from the MNLU and other universities to approach them for publication and other things. You can look into that. We have 2 students here also. I see they are working on the constitutional, particularly Anumeha Misra and Soril. Soril is working on the transformative constitutionalism, which looks into the transformative constitution from the South African Indian perspective and theory, like what Professor Mohan Paris has mentioned about the constitutionalism. So we see that in India, we are working on the constitution. Our scholars are equally doing very good work on the constitutionalism. And I see a great light, great opportunity, like Hannah is here, Robert is here, other colleagues are here, to interact closely and have more discussion and debate through this platform And individually, we can also work like, time to time webinar and seminar, webinar and conferences on the constitutional law, and try to understand the importance of the constitutional principles of the other jurisdiction, constitutional values, and implementation of the constitution provisions by the respective constitution, by the courts and other bodies. That will help us to understand the constitution and also bring all of us closer. With this, once again, thanks to the Professor Uke, Professor Aditya, Dr. Anilji, for bringing us all of here, of course, on the very limited space on the computer, but we are very happy to have and see all of you. Thank you very much. Over to you, Aditya.
Thank you, Manoj sir. It's always a pleasure listening to you. Now I invite Dr. Anil Variath. He's a professor of law and registrar at MNLU Mumbai for his address.
Respected Vice Chancellor, Professor Dr. Dilip Uke sir, Professor Dr. Manoj Kumar Sinha ji, Dr. Dayan Shah, Dr. Richard Albert, Dr. Hannah, Justice Mohan Paris, Dr. Kohilaben, and all other participants who have joined this online platform today. It's a very happy event that this South Asian Research Colloquium on Constitutional Law is being inaugurated today, and that too in the presence of luminaries like Justice Mohan Paris, Dr. Sinha, Dr. Richard, Dr. Hannah, and all. So it is a matter of great pleasure. When we were deliberating this colloquium, the directors as well as the institutions were much convinced about the need to have a serious discussion and debate on constitutionalism and comparative constitutional studies. And it has its significance because we have initiated this discussion at a time when the theme has a great relevance, especially in the light of the developments arising out of military coup and allied developments in Myanmar, developments in Pakistan, the complete breakdown of government and missionary in Afghanistan, and the controversy looming around the anti-defection legal regime in Sri Lanka, the entire controversy related to vaccine rollout in South Asia, the developments in India over the discussions and debates on dissent and democracy, things arising out of the CAA, rights of women, new dimensions to the women's rights and fundamental rights, new debates on nationalism, and all these things have made this colloquium very relevant and timely. And it is a time when we speak about the need to have growth and economic interconnectivity within South Asia. The economic growth and interconnectivity is possible only when we have better understanding about the government and systems within which the countries in the South Asia interact. So a meaningful debate, discussion, and deliberation on comparative constitutional studies in South Asia, according to me, would definitely lead to a good academic excellence, academic pursuit, academic scholarship. And I don't take much time. I just conclude by wishing the organizers a great success, and at the same time I call upon for all your cooperation in this endeavor. Thank you very much.
Thank you, Anil sir. To conclude, I now pass on the privileges to Dr. Kokila ma'am. She's a project director. She's a program director of this event, and also a very vibrant voice in the Sri Lanka. Over to you, ma'am, to deliver a concluding address.
Thank you, Aditya. Mohan,
Yes.
distinguished speakers, ladies and gentlemen. Paying gratitude for those who contribute to make an event a success is highly regarded within the South Asian heritage. Therefore, at the inaugural session on South Asian Research Colloquium on Constitutional Law, may I now seek your kind attention to the most valuable contributions made by the following dignitaries. First, let me most respectfully thank the resource persons. Professor Dr. Richard Albert, William Stamps Farish Professor in Law and Director of the Constitutional Studies, University of Texas, Austin, United States of America. Professor Dr. Hannah Lerner, Head of the School of the Political Science, Government and International Affairs, Tel Aviv University, Israel. Honorable Justice Mohan, former Chief Justice of Sri Lanka and the permanent representative of Sri Lanka to the United Nations in New York. Your valuable insights on constitutional law and inspiring thoughts on how to explore further and publish research in the area of constitutional law is exemplary. Many thanks for all of your contributions. Next, without the strong support from the directors of the partner universities, an effort of this scale could have only been a dream. A well-committed panel of directors made that dream a reality. Organizers' sincere appreciation goes to Professor Dr. Dilip Uke, Vice Chancellor, Maharashtra National Law University, Mumbai, India. Professor Dr. Manoj Kumar Singha, Director, Indian Law Institute, New Delhi, India. Dr. Jacqueline L. Neo, Associate Professor, Director of Center for Asian Legal Studies, Faculty of Law, National University of Singapore. Professor Dr. Anil Varia, Registrar, Maharashtra National Law University, Mumbai, India. And they also want me to mention my name, so beg your pardon. Dr. Kokila Kanasinghe, Senior Lecturer in Law, Faculty of Law, University of Colombo, Sri Lanka. A special remark of gratitude for Dr. Dian Shah, Assistant Professor, National University of Singapore, for delivering the welcome address. Last but not least, I would like to mention two names, of course, without their permission. I beg your pardon for doing that, gentlemen. They are none other than Aditya Variat and Amana Khare from National Law University, Mumbai, very cooperative and flexible program administrators of the South Asian Research Colloquium on Constitutional Law. Thank you so much, gentlemen. Thank you, technical, administrative, and other staff at the National Law University, Mumbai, who did their part to make today's inaugural session a memorable one. I conclude proposing vote of thanks with the hope that this inauguration ceremony marks the beginning of new ideas, visions, goals, and hope for constitutional laws and regimes that uphold justice, equality, and fairness. Ayubowan.
Thank you, ma'am. Thank you for all the participants for joining in for today's session. Especially to Hannah ma'am, who woke up really early. It's around 5:36 there, and to Professor Richard, who stayed up late. And thank you all. We hope to meet you again. And the schedule of the workshops have already been circulated. We hope to see you next week. Thank you so much. Thank you.
Thank you very much.
Thank you.
Thanks to everybody.
Yes, sir. Thank you very much, sir. Thank you.
Thank you.
Thank you, sir.
Thank you. Well done.